because the past 2 days she was delving into the law more than anything else, and then she delved a bit into the state's case. I wanted to hear what her thoughts were in terms of the defense case, how the defense presented its case, how witnesses, including the accused persons, were answering questions. And you could see, or hear rather, in the manner in which she was addressing, that she was far from impressed in the manner in which Malema was answering questions and, basically the demeanor in terms of the process itself. And what people don't necessarily know is that your demeanor counts very much towards whether or not you're going to be acquitted or you're going to be convicted. If you're going to be convicted, it may count against you in aggravation of sentence. If you're going to be acquitted, it's going to be counted in your favor in mitigation. So one of the things that the magistrate also pointed out was that the fact that there was a discharge of a firearm was not disputed by the accused, i.e. the Malema. So that was very crucial, because in terms of Section 120 of the Firearms Control Act, subsection 7, 8, and 9, this is where the state was relying on. And they were saying that it is irrelevant that the gun was a toy gun, the gun was not real. The fact that there's a discharge of a firearm already falls within the penalties that are cited in that. So that is really the crux of the case and the reason why he was convicted at the end of the day.
Okay.
What is happening outside, from at least a little bit that I've gathered, is that it seems that the judgment or the case was amongst two people in two different sets of facts, for lack of a better term, in that one person is charged with the discharge of a firearm, and then the other is charged with handing him the particular firearm. And then they were tried differently or separately, which is not the case. The only reason that the second accused, is it Mr. Sneeman, that he got acquitted, is because in terms of Section 120 of the Firearms Control Act, if I'm not mistaken, it's subsection 9, it states that if you can be found guilty if you're going to hand over a firearm to either one, a person who's not in his full mental capacity, so somebody who has a mental problem, or somebody who is not in their sound and sober senses. That's another category. And the third one is if somebody does not even have competency or a firearm license. So the first two are already out the window. The second one, it seems that the one thing that the Malema said in his own evidence in chief is that his gun was handed over by another person, I forgot the name, and that person was the one who was supposed to also be charged. So by his own affirmance, he's already given Sneeman an out, because that charge will automatically follow. Yes. So essentially, from what I gathered from the magistrates address today, part of the evidence that was given by Judge Malema himself was that he was handed over a gun by another individual, because that particular individual, in his testimony, he was saying that person ought to have been charged. So in that case, how then did Sneeman, who was his bodyguard, be the one to be charged? That's why there was not sufficient evidence to convict him on that particular aspect. And the other charge that he was also charged with, that this Sneeman, was that of a discharge of a firearm, which also did not make sense in the evidence that was presented before the court. So what ought to be known is that even if it could have been proven that it was a water gun at the end of the day, it's irrelevant. Discharging of a firearm or even pointing of a firearm is illegal in our legal system in terms of the Firearm Control Act. That's why, for example, look at robbery with aggravating circumstances, right? If you're going to be hijacked and then somebody points a gun at you, already it entices or gives you the impression that you're going to be shot if you don't comply with the instructions. That's why we call it aggravating circumstances. And even if it gets proven in court that the gun was a water gun, it's irrelevant because there was a pointing of a firearm. So that is why in section 120, it says that the discharge can either be an air gun, it can be an actual firearm, an antique, all of those things, and still you will be charged under that. He was convicted on discharge of a firearm. He was convicted on being in possession of ammunition, and he was also convicted on being in possession of a firearm without a license, basically.